Hi, I'm Scott Kiner. I am your host for this edition of Real Estate Today. This program provides meaningful information to homeowners who are dealing with the real estate crisis. My guest today is a prominent Palm Springs attorney, a real estate attorney and broker by the name of Mitchell Reed Sussman. Welcome, Mitchell.
Good to be here, Scott. Thanks for having me.
With the crash of the real estate market, the recession, and the worst job market in decades, many homeowners are turning to bankruptcy. The question or the topic of today's show is, can bankruptcy stop foreclosure? Mitchell, how does bankruptcy work, and does it help a homeowner stave off foreclosure?
The filing of a bankruptcy case invokes an automatic stay pursuant to 11 U.S.C. 362, and this automatic stay results in an injunction against any foreclosure, any repossession, any lawsuit, any collection activities. So yes, the filing of a bankruptcy under Chapter 7, 11, or 13 will stop a foreclosure.
So what is an automatic stay?
Basically, what it says is that immediately upon the filing of any bankruptcy chapter, 7, 11, or 13, an injunction will issue preventing a foreclosure or any collection activity or lawsuit.
So what type of things does an automatic stay prevent?
The automatic stay will stop the foreclosure, it will stop a lawsuit, it will prevent a repossession, and it will prevent collectors from calling you and harassing you.
So does an automatic stay permanently stop foreclosure, or can the mortgage holder continue with the foreclosure?
When the bankruptcy is filed, the automatic stay will stop the foreclosure, but not permanently. This is an automatic stay that exists during the term and course of the bankruptcy. So when the bankruptcy case is closed, the automatic stay dissolves or disappears.
Well, here's a question everyone wants to know. What exactly is adequate protection?
Adequate protection is what needs to be given to a mortgage holder who has filed a motion for relief from the automatic stay. And there's two basic forms of adequate protection. Number one is the equity cushion. By that I mean if you have substantial equity in your real estate, then the judge will not grant relief from the automatic stay based upon a substantial equity cushion because the mortgage holder is not damaged while you're temporarily in bankruptcy because there's a substantial equity cushion in the property. Unfortunately, in today's economy, there aren't that many equity cushions, and so the other way to prevent the motion for relief from stay being granted is to offer the mortgage holder adequate protection in the form of monthly payments.
Does it matter if I file Chapter 7 or Chapter 13?
By all means, it makes a difference whether you file a Chapter 7 or Chapter 13. In a Chapter 13, you get the opportunity to keep your home during the course of your plan because the Chapter 13 allows you to cure any arrears and it requires you to make your payments as they fall due. In a Chapter 7, which is a liquidation, the only way you're going to be able to keep the home is if there's a substantial equity cushion or if you make an arrangement with the creditor to provide these regular monthly payments as adequate protection. Chapter 13 is much preferable if it is your desire to keep your home.
Thank you, Mitchell. That was very informative. I'm sure our viewers learned something today that can help them through these very difficult economic times. That's today's show. But before we go, if someone viewing the show or a real estate professional has a particular topic or subject they would like to see on this show, you can reach me by email at scottk@kinercom.com. If you have a question about this show or a question for Mitchell, you can reach him by email at mitchell.sussman@palmspringsLitigationAttorney.com. Thank you for watching.